For a long time, data privacy in Nigeria was, well, kind of like the Wild West. But that whole era, it's officially over. We've seen this massive shift from some vague guidelines to a really powerful new law. And trust me, it affects every single person and business in the country's booming digital world. So, let's break down what's changed and what it all means for you.
I mean, really think about it for a second. Your name, your location, your bank details, your health info. Every time you use an app, shop online, or just browse a website, you're handing over little pieces of your digital self. But who's actually in charge of all that information? Well, up until recently, the answer to that question has completely, and I mean completely, changed.
Now, this whole transformation didn't happen overnight, but in the world of government regulation, this moved at lightning speed. Here's how it all went down. Back in 2019, we got the NDPR, which was a good start. It got the conversation going. Then, boom, just 4 years later, in 2023, a powerful new act becomes the law of the land. And now, looking ahead to 2025, we have the GAID Directive, which is basically the official playbook telling everyone exactly how to follow the new rules. It's been a rapid journey from a suggestion to a serious mandate.
All right, let's kick things off at the beginning. How exactly did Nigeria's data rules go from a gentle suggestion to a law with a very, very serious bite?
You know, the difference here is just night and day. Before 2023, the rules were basically just secondary guidelines, kind of tucked under an existing IT agency. So enforcement, pretty weak. But now, we have a primary federal law, the NDPA, and what's really crucial is that it's enforced by a brand new independent commission that has the power to hand out massive fines. This isn't just a small tweak, it's a whole new ballgame.
So, circle this date in your mind. June 14th, 2023. This is the day everything changed. The Nigeria Data Protection Act, the NDPA, became law. And this wasn't just another update to the rulebook. No, this was a creation of a whole new legal foundation for data privacy, one designed to support Nigeria's digital economy as it grows.
Okay, so with a new law, you need someone to enforce it. Let's talk about who's in charge of this new reality. It's time to meet the new sheriff in town, the Nigeria Data Protection Commission.
So this is the NDPC, and it's not just another government department. The key word here is independent. It was created for one specific reason, to protect your data. And that independence is so important because it means they can regulate, investigate, and enforce the law without anybody telling them what to do. They have real authority.
And their powers? Oh, they are extensive. The NDPC can launch an investigation into pretty much any company they want, run audits, and, as we'll see, issue some game-changing fines. They also have this unique power to label certain big companies as data controllers of major importance, which puts them under a serious microscope. They even have a say in how data flows in and out of Nigeria. They're involved in everything.
So we have a new law and we have a new sheriff. But how do businesses actually follow the rules? That's where the next piece of this puzzle fits in. It's called the GAID 2025 Playbook, and it basically translates all that legal language into specific, concrete actions. Okay, first you gotta know this acronym, DCPMI. It stands for Data Controller or Processor of Major Importance. Here's the deal. If your organization handles data for more than 200 people over a 6-month period, or if you work in a key area like finance, health, or e-commerce, then you are a DCPMI. And that little label comes with a whole new world of responsibility.
And it's not a one-size-fits-all situation. The GAID Directive set up 3 different tiers of compliance. Right at the top, you have the ultra-high level, or UHL. Think massive banks, big telecom companies. A step down is the extra high level, for places like government agencies and major hospitals. And then there's the ordinary high level, for smaller groups like schools and hotels. And as you can see, each level has its own registration fees and its own set of rules to follow.
So what do businesses actually have to do now? Well, the list is pretty clear. They have to appoint a certified data protection officer. The big guys, the UHL and EHL tiers, have to file a detailed compliance audit every single year. Before they launch any high-risk project, they have to do a full impact assessment. And get this, if there's a data breach, they have just 72 hours to report it. Even something we see every day, like website cookies, now needs your clear opt-in consent. No more funny business. All this is great for holding companies accountable for sure, but what does it all really mean for you, the individual? Well, it means you've got a new deal. You have more power over your own personal information than you have ever had before. You now have this incredible set of rights. You can demand to see what data a company has on you. You can tell them to correct it if it's wrong. You can have it completely deleted. That's the famous right to be forgotten. You can tell a company to stop using your data for marketing. You can even take your data with you and move it to a competitor. These rights really do put you back in the driver's seat.
And check this out. This is a real game changer. It's called a snag. That stands for Standard Notice to Address Grievance, and it's a formal tool that puts the power to act directly in your hands. If you think a company has violated your data rights, you can issue a snag to them before you even have to get the regulator involved.
And using it is pretty straightforward. Step 1, you think there's been a violation. Step 2, you send that formal SNAG notice directly to the company. Step 3, they are legally required to fix the problem. And it's only if they fail to do that or ignore you that you then escalate it to the NDPC. It's like a powerful first line of defense for every single citizen.
So what happens when companies don't listen? When they don't comply? Well, this new framework is not just talk. The stakes are incredibly high, and enforcement has already kicked off in what some people are calling the year of the teeth.
Just look at this number, 555.8 million naira. That is the fine that was handed down to Fidelity Bank for violating the new act. I mean, that is not a slap on the wrist. That's a clear, loud message that not following the rules is going to be incredibly expensive.
And that wasn't a one-off. MultiChoice Nigeria got hit with an even bigger penalty, over 766 million naira for privacy violations, including illegal data transfers. The NDPC is making it very clear that they will use their powers to enforce the law, no matter how big the company is. This quote really says it all, doesn't it? In Nigeria's new digital world, accountability for how you handle people's personal data, it's not optional anymore. It's the absolute baseline, the new rule for everyone.
So, if you remember just one thing from all of this, let it be this. Data protection in Nigeria has gone from a suggestion in some old rulebook to a strictly enforced reality, with huge financial consequences for anyone who fails to keep up.
And that kind of leaves us with one final thought. Nigeria is building one of the most dynamic digital economies on the planet right now. So the big question is, how will this new, delicate balance between pushing for rapid innovation and guaranteeing personal privacy, how is that going to shape the country's digital future?
Comment, like, share, and subscribe.